All right, I got it. All right, welcome to another class of Get Closed, Get Paid. Today, we're going to do a review of the MLS and NAR changes and broker compensation forms. This will sort of be a recap summary of everything that we've been teaching for the last year, for Kristen for the last 6 years, but for me for the last year. Every time we've taught this class, we've had to update and revise it because new forms have come out, new rules have come out. We've had a better understanding of what the changes are, but we are here on August 13th, just before the official August 17th change date. And so we're going to go through everything that you need to know to stay in business and stay compliant as we go through some of these compliance hurdles. Today, my name is Erin Miller. I'm a real estate attorney. I do real estate closings. I've got a law firm and a title company based out of Naples and Jupiter. And my colleague is Kristen Jaiven. She does not do closings. In fact, she represents brokers and agents, and her phone line has been busy lately, helping answer broker questions and represent them in either creating forms, litigating, enforcing buyer-broker agreements or disputes regarding compensation. So we are, again, get closed and get paid. We're going to jump right into our very first slide that I joke is my favorite slide, but it is really my favorite slide. This is our attorney disclaimer. This presentation does not create an attorney-client relationship. Kristen and I do serve on a number of committees, both with the Florida Bar and Florida Realtors. So the opinions that we get today are just our opinion. They are not necessarily reflective of the opinions of the committees on which we serve. Also, this is a forum for the sharing of ideas, so I have to give our anti-antitrust statement. We're not going to be, even when we answer questions later on, we're not going to be engaging in anti-competitive behavior. We won't give examples using numbers. We're going to go sort of broad general discussion regarding compensation when we do. All right. We're going to dive right in today. Our agenda. We're going to talk about our practice changes that are effective August 17th. And note that we're kind of in a messy middle right now, as some of the MLS organizations have removed offers of compensation from their listings as of now, some as of a couple of weeks ago. So these practice changes regarding buyer broker compensation will be effective August 17th, but we're sort of in a weird middle time. We'll talk about getting through those changes. First, we're going to talk about understanding the listing agreement, understanding our buyer broker agreement, review some commission forms, and then we'll talk about commission rebates, concessions, and credits, and then some practice challenges, and then we'll answer your questions. All right, I'm going to dive into the very first slide regarding practice changes. So we know that part of the proposed NAR settlement involves not only a monetary fine of $418 million from NAR, but also included some practice changes. So we'll just review those real quick, get them fresh in your brain. The practice changes included MLS eliminating and prohibiting requirements that a seller offer compensation to buyer brokers or buyer representatives. Also removes compensation from the MLS. So you cannot make offers of compensation on the MLS or disclose compensation anywhere on the MLS. Important dates for you. Again, today is the day that one of our local boards has removed offers of compensation. Tomorrow, another local board is making that switch. So if you have a current buyer under contract right now and your board has not removed those offers of compensation, go ahead and print your MLS info just so you have it handy in a file folder somewhere, just so you know what that offer of compensation was when your buyer went under contract. Number 3, MLSs are required to eliminate those broker compensation fields on the MLS, and again, prohibit completely the sharing of offers of compensation on MLS, and it prohibits conditioning the listing on MLS on offering compensation to buyer brokers. Again, previous policies by some of the boards was to have a requirement of an offer of compensation of a penny, of $1 to a buyer broker. Now there is no conditioning of a listing on MLS based on offering compensation to a buyer broker. Kristen, what else we got?
Okay, so let's talk about the buyer broker agreement. So now compensation, as we know, advertisements on the MLS are coming off of the compensation's coming off the MLS. And the 6th bullet point, which is really a practice change that a lot of realtors are trying to get used to at the moment, and that is that all brokers are going to be required to enter into written agreements with buyers before they tour a home. So that definition has kind of been reworked since we first saw the settlement agreement come out. And the definition that NAR has kind of been working with is called working with. So the working with definition is the moment in time where you're starting to provide services to the buyer. So if they're just passively in your CRM receiving advertisement, that's probably not working with. If they're dictating, if a buyer is dictating what kind of properties they want to see, and you're looking in the MLS and culling data to try to figure that out, then you're probably starting to work with. If you're showing property and scheduling listings, you're definitely working with. Before you can do that, you have to enter into a written buyer broker agreement, and that buyer broker agreement has to have 3 things. The agreement must disclose the rate of compensation that you are expecting to receive for providing broker services. Second, the amount of compensation must be objectionably ascertainable and may not be open-ended based on what the seller is offering. What that means is you have to set your commission price in advance of showing properties based on the number that you want to receive, independent of any kind of outside factors. C, the realtor may not receive compensation for services in an amount that exceeds the rate in the buyer broker agreement. This prong of the settlement has kind of been giving everyone the most heartburn, because there's situations where you might be working with a buyer trying to set that commission rate. The buyer might be concerned about out-of-pocket expenses at closing. And that amount is lower than what you want to get paid. We're going to talk about how to maneuver some of those situations, but just know when you sign that buyer broker agreement in advance of showing properties, you can't accept more compensation than what's in that document unless you go back and amend that agreement. So that you're setting almost a cap when you initially sign that contract, and that's dictated by the settlement agreement. Yeah, if you want to get through, or you want me to do these as well?
Oh, I can do them.
Okay.
So
and before we go to the next slide, I'm just going to do a brief overview of the settlement. Okay.
Oh, please go for it.
No, go ahead. Finish the slide and then I'll go.
Okay. All right. So one of the practice changes, and I'm sure nobody on the Zoom call would ever say this, that buyer agent services are free. We are removing that from our vocabulary altogether. You cannot represent that your realtor services are free. It may be the case that you have a buyer who signs a buyer broker agreement, and perhaps the obligation of that buyer to pay that buyer broker fee may be offset by a third party, maybe by the seller, maybe by the listing broker, but there's no universe in which your services are free unless you're actually not getting paid anything at all. So number 8, we need to make sure we're conspicuously disclosing to sellers and obtaining the seller's written approval for any payment or offer of compensation to a buyer's broker. Again, you'll see that in our listing agreement forms. It is very clear whether the seller is opting in to provide any compensation to a buyer's broker. So there's no scenario in which a listing broker gets their compensation and says, well, it's out of the goodness of my heart, I'm not going to bother the seller with this, but out of the goodness of my heart, I'm going to go ahead and pay compensation to a buyer's broker. No, we need to make sure we've got the seller's approval to offer any payment of compensation to a buyer's broker. Also, need to conspicuously disclose to all customers that broker commissions are not set by law and are fully negotiable. This I'm calling the big, bold language. I want to make sure that big, bold language appears on all of the forms. So if you have forms in your database that are in the process of being updated, you'll note that anything dealing with compensation likely now has this big, bold disclosure language. Broker commissions are not set by law and they're fully negotiable. Also, 10 will disallow MLS subscribers from filtering listings based on compensation. Again, this will sort itself out because offers of compensation will no longer be on MLS, and so there's no way to filter on MLS listings based on compensation. But we'll continue with that at a buyer request a little bit later. Also, we do have a link to the website. Again, we'll send these slides to you after the presentation. If you are not yet familiar with the NAR Settlement FAQs, they were recently updated as late as last week. So make sure you're updating any of the questions you have sort of on the grand scheme of the settlement, not your local MLS and not Florida Realtors, but sort of the grand scheme of the NAR Settlement. You will likely find those answers on the NAR Realtor Settlement FAQ. And then real quick, I request, can everybody please make sure you mute yourself because we are recording this. All right, Kristen, tell me where we are with the settlement itself.
Yeah, so I don't want to get too far into the settlement. You know, we're here because of a settlement of a class action case arising from antitrust type claims, which is why we gave our antitrust disclaimer. But I just want to make a note because I keep getting questions, are these changes now law? And the answer is that these settlement changes that we just went through, the practice changes that we just reviewed, are arising out of a settlement. That settlement was entered into by the National Association of Realtors. It has preliminary approval, but it's not expected to receive final approval until November. So you might be asking, why are we making changes today when it might not receive primary approval? And the answer is,
right. I'm going to need insurance card, driver's license, new patient, right?
Mary, can you please mute yourself?
I got her.
Richard,
Okay.
please mute yourself. Oh, thank you.
So the hold on. Yeah, there we go. So the settlement in that case is not expected to receive final approval to November. Does have preliminary approval, but that does mean that there could be additional practice changes. These are not changes to Chapter 475. These are not changes to the licensing rules. These are changes that were agreed to, and if in order for brokers to be covered under the MLS settlement, you have to follow these changes. These are also changes that the National Association of Realtors is required to make. So these changes are all going to flow down through membership. So if you're a member in NAR, if you're a member of an MLS, you're going to have to follow these rules, and those will eventually get rolled into, I suspect, I don't work for FR or NAR, but I suspect there will be changes to the Code of Ethics. You're already seeing changes to MLS rules. You're seeing extremely stringent and harsh punishments if you violate some of these MLS rules, i.e. you try to put commission somewhere in that MLS listing, there's going to be really harsh punishment. So this is not a change to Chapter 475. This is not a change to licensing rules. So if you've got brokers that are out there operating in it and they are not part of NAR, they might be showing properties without broker agreements. If you do something to that effect and you are an NAR membership, you're putting your inclusion in the settlement at risk, and you're putting yourself potentially in rule violations with NAR. So I just want to give that distinction because I get a lot of questions up front. Is this a legal change? Yes and no. The answer is great. We're lawyers, and that's how we answer.
All right. Okay. So let's talk about what the practice changes do not do. So these practice changes do not prevent offers to buyer brokers outside of the MLS. Again, you can continue to negotiate your compensation outside of the MLS. It just cannot appear in the MLS listing. It also doesn't prevent sellers from offering buyer concessions on the MLS as long as the concession is not conditioned or tied to the payment of a broker. I have an asterisk there because you really need to follow your local MLS rules with respect to offers of concessions. Some boards may not allow reference to concessions whatsoever. Some may have a concession field. Some may allow you to include reference to concession, but not the dollar amount. So again, double check with your board. And if you practice in multiple boards, I'm so sorry, you're going to need to make sure that you comply with each board's requirement. So I would probably aim for the most strict requirements as your guidepost if you're going to be, posting in multiple boards or advertising multiple boards. Again, advertising concessions varies by your MLS rules, and the practice changes do not address commission on rentals. We will see in some of the new revised forms, they still do address lease compensation, but the practice changes themselves under the lawsuit do not address rentals. For practical purposes, though, many of the boards who have removed that compensation field with respect to residential purchases and sales have also removed those offers of compensation reference on the MLS with respect to rentals. So you're still going to need to get some documentation between the listing broker and your broker, or some documentation from the landlord to pay compensation if it's no longer going to appear on MLS. So just a side note there. All right. Quickly about the DOJ, you've heard that DOJ is interested in this topic of compensation and cooperative compensation with the National Association of Realtors. So back in 2020, the parties NAR and DOJ reached a settlement of its investigation. DOJ reopened its investigation, NAR challenged, DOJ appealed, NAR petitioned for a rehearing in May of 2024, and that was recently denied, which means DOJ can continue to investigate the practices by the National Association of Realtors. That's sort of one point. The second point, we've got another case where the DOJ has actually filed a statement of interest, and that's how we know kind of what the DOJ wants or what the DOJ would like to see. That case has been stayed until after the Citroën approval or final judge approval in November of 2024, and then they'll continue with that case. Also, you may have heard in the news that the DOJ did file a formal inquiry into the California Association of Realtors just as they were about to release their entire forms library with the forms updates. And so they delayed the release of some of their settlement-related forms pursuant to that formal inquiry. So we know that the DOJ is sort of interested in what's going on in our industry, but what do they really want? They would love to have decoupling, prohibiting offers of compensation to buyers, brokers, by listing brokers or sellers. So I'm going to speak to the DOJ when I say, in the DOJ's perfect world, they'd have a buyer pay the buyer's agent only, and a seller pay the listing agent only, and no cross between the two. No outside party paying that compensation. Again, that is sort of their starting point, but we're hopeful perhaps that they will not, the DOJ will not intervene in the Citroën case officially, and perhaps they'll allow these practice changes to proceed. All right, Kristen, how can our realtors navigate this shift?
So upfront, how I've been starting every class before we dive into all of these forms, because I feel like everybody right now in this industry is just getting a little overwhelmed on what process do I need to follow now? We had a process, the process is gone. What do we do next? So I want to start by telling everyone that the issue you are faced with is a math problem. It is a math problem. It is a negotiation problem. And really that's it. If you can keep that in mind, that if you are a sharp negotiator and if you understand the numbers behind real estate transactions and how all elements of a real estate transaction get negotiated, from purchase price to down payment to inspection credits, all that kind of stuff. If you can kind of understand all of those numbers that go into getting that transaction and understand your buyer's needs when it comes to their finances and the seller's needs when it comes to what they're looking for in the sale of their home, then you can put these deals together. You just got to know what paperwork to use. And that's what we're going to explain now. So you've got a math problem. That's all it is that you have to solve. Number 2 and 3, which is the biggest things I want everyone to know, is that what got us into this hot water, what got the industry into this hot water, I should say, is that there was commissions being shared across the MLS in a fairly uniform fashion. That is what kind of, and to a certain extent, buyers and sellers were kind of in the dark as to how commission was paid. And that's kind of what created some of these issues. So if you go into every transaction with transparency to the consumers, transparencies to the sellers, transparencies to the buyers as to how commission is paid, you negotiate each deal on a unique basis, and you get the parties where they want to be, or as close as you can, to what their financial goals are, then you're going to be in great shape. You've just got to be transparent with the parties, and you've got to negotiate deal to the best of your ability. The other thing that we've been recommending, and we've been doing this for a long time, is that you articulate your value in the transaction. I think there's a lot of misconception as to what realtors do in the transaction. And part of that is based off of what realtors do on a normal basis to try to protect their clients. So one of the things you do is do a lot of things behind the scenes. You're calling, you're emailing, you're working the deals, you're doing all these things, and you're kind of insulating your clients from time to time as to all those nitty-gritty details. Now is the time to make sure they know how many text messages, how many calls, how many requests for feedbacks do you send on a listing. All of those little things that you do that maybe you never communicated to your client because you thought, I don't need to bother them with them because they need to know all the hours and the time that goes into these transactions. I represent brokers a lot in commission disputes. And when I go through their emails, it is always fascinating to me how much service was provided on behalf of a seller or on behalf of a buyer, and the buyer's not copied into those emails. So they have no idea how much work was going on in the background. So now is the time to articulate your value in the transaction and communicate all of those services that you do. And I think everyone in the industry should be doing that, because having representation on the seller side, on the buyer side, is super important for folks who are making very, very big investment and financial decisions, and they need someone to help them. So now is the time. Now we're going to get into the document. So Erin kind of mentioned nobody should be going into the world today without written contracts documenting every type of commission that might be getting paid on a transaction or compensation. If you're getting paid on the listing side with the seller, if you're getting paid on the buyer side by a buyer broker agreement, if there's any concessions, credits, or commissions being paid in any other way, it's got to be put to contract, or else you're going to be potentially putting yourself in a mess to get paid. Don't make any assumptions that you're just going to magically get paid at closing, because we're in a new world. So everything has to be put to paper. And we're going to try to.
I was going to say, yes. So none of the text message confirmation or verbal, yeah, I got you. I'll cover compensation. Like, make sure it is documented between the parties, and we'll talk about how that can appear. So we're going to go through a few examples of hypothetical scenarios, and then we'll dive into the documents themselves that we're going to reference here. So our example: buyer enters into a buyer broker agreement with a buyer's agent agreeing to pay X for the buyer's agent services. So that's sort of our starting point, right? Buyer agent has an agreement with their customer, and the buyer agent is expecting to get paid X for compensation. The buyer agent will contact the listing agent to see if the seller or the listing broker are offering commission to the buyer's agent prior to submitting the offer. So in option one, scenario one, let's say the listing says, no, we're not offering any compensation to a buyer's agent. Then we know that buyer would be responsible for paying X to the buyer's agent at closing. So that would be our purchase price plus X, right? That would be due to the buyer broker. Option two, commissions offered to a buyer's agent directly, either from the seller or through the listing broker, and negotiated in a separate agreement. So again, buyer broker calls the listing agent and says, is the seller or are you, listing broker, offering compensation to me as a buyer's broker? If the answer is yes, document, document, document. So Florida Realtors has two forms that you can use: the CASB from a seller to a buyer broker, or the CABB from listing broker to buyer's broker. You're going to document that offer of compensation to the buyer's agent coming from a third party. Option three, let's say that their seller's not offering compensation directly to a buyer's agent, listing broker's not offering any compensation to a buyer agent, but the seller wants to offer, as part of the negotiation between buyer and seller and the sales contract, the seller's offering a concession to the buyer directly. So this would be negotiated and documented in the sales contract or an addendum to the sales contract. So a concession could be towards closing costs or prepaids, and or towards the buyer's obligations to pay the buyer's agent. So again, option three would be a seller concession negotiated in the body of the sales contract, seller providing credit to buyer towards closing costs and or potentially towards the buyer's obligations to pay the buyer's agent. So those are sort of our overarching hypothetical scenarios. I know it gets a little bit messier in reality, but this is what we're starting with. All right, Kristen, tell me about the big picture listing side, how this works.
Okay, so we're going to focus on the Florida Realtors forms. We know there's other forms out there. Some of the local boards have their own forms. Some brokers have their own forms. We are aware. We're going to focus on FR for the purpose of trying to give a global direction to everyone as to how this kind of lays out. But we know that there's other forms that can accomplish this. And there's probably going to be a lot more forms created. I think I get a new form to create every single time I open my email. So I know there's lots of contracts out there. The other thing I just want to address, the elephant in the room, so to speak, is that there have been some brokers out there that said that they are large brokers that said they're not going to have commission be offered from a listing broker to a buyer's broker. Any compensation offered related to that will be paid directly from a seller to a buyer's broker. We're aware of that, so we're going to teach you how to maneuver all those circumstances. We're not going to provide any comments on whether we think it should be done that way or done a different way. We're just going to tell you what forms would be used in each scenario. So big picture, so everybody kind of understands where they're at, is the first side is if you're representing listing. So you right now, listing agent, are representing a seller. What document do you need to execute? That is a listing agreement. That, unlike all these other contracts, is actually required under Chapter 475. So if you don't follow the listing agreement, you're going to put yourself in hot water and have a licensing issue and see yourself before FREC. So the first document that you have to execute is between the seller.
Yeah, we have a lot of our agents in here.
Hey, Jess, can you mute yourself, please?
Yeah, got it. So
Okay.
between the seller and the listing agent, you enter into the listing agreement. That listing agreement, you're going to do two things. One, you're going to set what your listing commission is. What is your commission if you represent the seller and provide services to the seller on their side of the transaction? That's what you're going to set in your listing agreement. For the purpose of illustration, we're going to use the Florida Realtors listing agreement. The second thing you're going to do is set what your commission is if you represent the buyer. So you're working in a transaction broker relationship, you're representing the buyer. You're going to determine what that commission would be if you work both the buyer side and the seller side of the transaction. The third thing you're going to do in the listing agreement related to compensation is you're going to work with your seller to determine if any compensation or concessions is going to be offered to a buyer's agent or a buyer in connection with the transaction for the purposes of advertising the property or offering compensation, things of that sort. We're going to go through in the new listing agreement how you make that determination, but those are the three things you need to accomplish related to compensation in your listing agreement. The listing agreements have no default provision, so if you skip a line and don't fill out the paragraph and it's blank, you're going to be compensated blank, which is 0. So seller, listing agent enter into a listing agreement. Related to how a seller may want to offer compensation to a buyer's agent or a buyer to offset expenses to a buyer's agent, you've got 3 options in the new FR listing agreement. The first option is the listing broker is authorized to offer compensation to buyer's broker. Can you see my pointer or no, Erin?
I cannot see your pointer, but I can point where you'd like me to point.
Yeah, can you point there? Yeah, there you go. Okay, because you're sharing. Second is seller to buyer's broker.
Okay. Yeah.
And the third is no compensation is offered. So you're going to see in a minute, this follows directly the compensation paragraph in the listing agreement. If your seller wants to go with option 1, listing broker pays the buyer's broker, then the form you need to document that is CABB. If you go with the second option, the seller is going to pay the buyer's broker directly, then the form you need is FRCASB. And if they go with no compensation, then we don't know what form you're going to need because it's all going to be subject to negotiation. What's important to note is that the listing agreement, this is what the seller agrees can be offered on the transaction. That does not mean what the seller is going to ultimately agree to. So the example I like to give is when you enter into the listing agreement, the seller is going to tell you what price they want the property advertised. Does that mean, so you set your list price, does that mean a seller won't accept anything under a list price? No, we know that. Everything is subject to negotiation. So even if they say they don't want to offer any compensation, if they get a fabulous offer on a full price offer on a transaction and they're asking for some concession towards buyer agent commission, the seller might be interested in that. So that's why we say, even if they check C and no compensation, that's still subject to negotiation. Once it's determined how that gets paid, then you figure out what form you need. So those are kind of your 3 options as of right now. Now that we're all kind of oriented, let's look at the actual language. Okay, so paragraph 9, I added this just so everyone is aware that it's there. Paragraph 9 to me is a new consumer type of disclosure that explains what buyers brokers do. Under subsection C, it also gives notice that the broker may receive separate compensation for services rendered to the buyer by the broker. That is kind of your double ending the deal language, okay? So that paragraph 9 explains to sellers what a buyer broker does. So when you're presenting this listing, I would work with 9 and 10 together. That way you can explain what the buyer agent is in 9 and then flip down and have the conversation about how the seller wants to offer compensation to the buyer's agent. You have 3 options. Option 1, we just reviewed on the chart, is seller authorizes broker to offer compensation from broker. The second is seller authorizes broker from seller. And the third is no compensation. Important, if you can highlight it for me, Erin, is the last sentence in A and B.
Go ahead. Yes.
This compensation will be set forth in a separate written agreement. Why is that? So they're agreeing to what can be offered, but it has to be memorialized in a separate written. The reason behind this is historically, when you had the MLS and you had the MLS offer of compensation, by membership in the MLS and agreeing to those rules, you were entering into a quasi-contract with protections as to enforceability through the Board of Realtors every time you made an offer on an MLS listing. That is gone now. So there is no contract to memorialize that commission unless it's done in a separate contract. So whether you pick A or you pick B or you pick C, or the seller, wants to offer some sort of combination thereof, or they're not sure yet, so they're going to enter into C and wait to see how offers come in, you're still going to have to document anything that's agreed to through the contract. So if we could go back up to the listing map.
Maybe.
For our regulars, you know that Erin and I are not tech savvy. So every class is a little funky, but we hope that we make up for it in our legal analysis. Okay, so the listing broker to the buyer's broker is the CABB. So that's your subsection A on 10A. 10B is your CASB. That's a seller to buyer's broker. No compensation is what you're going to negotiate. And we're going to get into a minute of how you would document concessions. Yeah, that's through the purchase contract. We'll explain that on the next slide. Okay, moving on from listing. Buyer side. So this is what's new. Okay, so if you are a broker working with a buyer, we already explained the definition of working with. Working with is providing services to the buyer beyond some sort of passive advertising. You have them in your CRM, they're getting emails like everybody else you've ever met. That's not working with. Working with is you're working with the buyer to determine what kind of purchase they want to make, and you're actively starting to provide services. At that moment, you need to enter into the buyer broker agreement. So buyer agent, if you want to do the pointing for me. Erin. Buyer agent enter into buyer broker agreements. As of right now, the buyer broker agreement is not dictated by Chapter 475. So this agreement is mandated by your involvement in the settlement, and you're a member of NA and your membership in NAR, but this is not a Chapter 475 regulated contract as of right now. Okay, so you enter into your buyer broker agreement and you set your compensation of what you want to be paid on the buyer side of their transaction for providing services to that consumer. So agent buyer set their commission at that time. I know this is hard because there's going to be buyers that can't pay, and we're going to talk about that. But right now, you're going to set your commission at this time. Okay. From there, you've got to negotiate. This is your math problem. So there's lots of ways this can be played out. And this is where the agents that are able to negotiate and think of creative solutions are going to shine. So let's go through it. First option is who pays that buyer. So let's go through who's going to pay the buyer's commission. So you set the amount through the buyer broker agreement. Who's going to pay it? Option one, buyer pays. If the buyer pays, the contract you're going to rely on is your buyer broker agreement. Possibly need to amend that. I also have in little tiny print or the showing agreement, I propose that everybody use an exclusive buyer broker if you're providing transactions, but there is another contract out there if you're not ready for an exclusive relationship. Erin likes to call that the dating contract. So if you would like to date.
Right, the buyer broker agreement, yes.
And the buyer broker agreement is the prenup. Okay, so buyer pays, you're not going to need an additional contract because you're already going to have entered into your buyer broker agreement. You may need to amend it if compensation terms have changed, but you're not going to, you're at the closing table, you're going to force the buyer broker agreement and you're going to be paid from the buyer. Second option is the seller agrees to pay the commission or part thereof. Then you're going to need the CASB. Third option, the listing broker pays. Then you're going to need the form CABB. And the third option is the seller agrees to give the concession to the buyer towards their buyer commission expenses. If that's the case, that gets documented in the purchase agreement. And it could be any combination thereof. So real quick on the purchase contract, nothing goes in the purchase contract related to commission unless it's a concession of funds between a seller and a buyer. The reason for that is that you as a broker are not a party to the purchase contract. So if you try to stick your commission in there, you're not signing it, so you're not going to be able to enforce it. So the only thing that really is appropriate for the purchase contract is, hold on one second, let me do a mute, is going to be a shifting of funds from the seller to the buyer. Okay, when I say any
Can you
comment,
say that just one more time? Can you just, because it's really worth repeating, because I received a contract yesterday to review that has some very interesting language that has nothing to do with a credit from seller to buyer. And so what in the sales contract, what do we want to see? A concession from seller to buyer, a credit from seller to buyer. And who are signing the sales contract? Seller and buyer.
So if you want to think about it
yeah.
this way, because we will just scare you on this, the buyer and the seller sign that contract. So there is nothing to prevent the buyer and the seller from amending that contract and deleting your commission paragraph that you added in. They could cut you out, delete it, and it wouldn't even matter because it possibly wasn't enforceable in the first place because you weren't a party to that contract. If you do something like that, you might be able to create some creative, equitable arguments in court. But I'm telling you, those types of challenges are not easy legal proceedings to endeavor. So I'm not saying you wouldn't have a claim, but I'm saying it would not be pretty. So the purchase contract should be limited to the buyer and the seller. Transfer of concessions, transfer of credits, and that would be it.
All right, go back to your combo.
Okay, or it could be a combination thereof. So say you enter into your number X with the in the buyer broker agreement. So you've got your number, you know what you're getting paid. Seller only offers Y. Am I doing this right? Am I going up and down?
Yes.
Okay.
Yeah,
Only
you're
offers
doing well.
Y.
Yeah.
Then the difference is going to be paid by the buyer. So in that case, so seller agrees to pay Y. So on the HUD, the seller side has Y figure written in. And that difference, the additional amount the buyer agreed to pay, ends up on the buyer side. So that's the combo. Okay.
Same with listing broker. So if what the listing broker is paying is less than what is in the buyer broker agreement, again, listing broker pays. If it's not covered either by a seller concession in the sales contract or by some seller offer of compensation as the ASB, then the difference between what the listing broker is paying and what the buyer's paying is going to be, buyer's going to be paying on the settlement statement. So when we think of things that buyers are going to be coming out of pocket for, again, to the extent that the buyer broker compensation is not offset by somebody else, buyer's going to be paying purchase price plus buyer agent compensation. So think about, again, you've got a purchase price of $1 million. It is purchase price plus buyer agent compensation on the settlement statement to the extent that it is not offset by some other party. All right, we ready to go to the next slide? We're doing it.
So just a quick note, remember anything that you set in the buyer broker agreement has to be, you can't accept more compensation. This is part of the settlement. You can't accept more compensation than what's in there. So if you find yourself in a situation where potentially the commission offered is greater than what's in that, you would have to go back and have a conversation with your buyer as to whether you can accept that higher amount. Okay. And then you would have to amend your buyer broker agreement to account for that. There's some problems, I think, with that approach that could arise. So my suggestion is that you make sure that compensation in your buyer broker agreement is the amount you actually want to work for and be paid. Okay, let's dive in quickly. We've already reviewed the buyer broker agreement a few times in our classes, and those videos are available. So we're going to go through the buyer broker agreement pretty quickly because that way we can get to the new forms. But you can always go back to our classes.
Yeah, so this
is
exclusive buyer broker agreement. We're going to allow for questions at the very end, Crystal. I promise we'll have plenty of time for questions. Just write it down, and because we are recording, we're not going to allow questions live on the recording. But we are going to go through very quickly that exclusive buyer broker agreement. What I want to note is that there are, with Florida Realtors, 4 versions of the exclusive buyer broker agreement. Look at the footer of the form. The footer bottom left corner will tell you what version of the form you're looking at. So the form that ends in TB, EBBA-7 TB, 7 is the most recent version. TB is for transaction brokerage. We're making an assumption that most of us are working in a transaction brokerage capacity. You won't find that TB language anywhere at the top. Again, all of the forms are going to look the same at the top. It says exclusive buyer broker agreement. Drop down to the footer and see that it says 7-TB if you're looking for the transaction broker agreement. And this is an agreement between the buyer and the broker. It says consumer now because this form now deals with also deals with leases. So we're using this sort of all-encompassing term, but I'm going to use the word buyer because it's easier for my brain. So between the buyer and the broker, meaning the brokerage, are working in this exclusive relationship. Think of this again as your real estate prenup for a period of time. During the term in paragraph 2, the parties agree to work exclusively, buyers agreeing to work exclusively with this particular broker for the purchase or acquisition of a property. Look with me in paragraph 3. This is where some folks might get into some trouble. So make sure you're describing the type of property that they're looking for. If they're looking for any type of real property in Florida, then put any real property in Florida. If they're looking at residential, use residential, mixed use. I would say the cautionary tale that we would say is don't limit. If the buyer says, I'm looking for single family homes only, and you put in single family homes in Miami-Dade County, and the buyer ends up acquiring a condo in Stewart, you've got the terms of your agreement are for a single family home in Miami-Dade, you're going to have a really hard time enforcing, right? Because you're going to really have time enforcing this buyer broker agreement against the buyer because that wasn't the type of property that you were engaged to search for. Before, just pause real quick. Before you ask the buyer to enter into one of these exclusive buyer brokerage agreements, ask if they've already signed one. Ask if they've signed something. Ask what they've signed, because it's possible that they have signed an exclusive buyer brokerage agreement, but maybe it will terminate, or maybe it's for, they entered into one for searching for property in the Panhandle, but you're in Southwest Florida and you intend to work this particular buyer for looking for other properties in Southwest Florida. We're not going to read through them, but just these are the broker's obligations. Again, this is an agreement between the parties. Make sure you're going through this in detail with your customer. If you look in paragraph 4A, these are things that you already do. These are not very difficult legal requirements that you're obligating your brokerage to do on behalf of your consumer. These are things that you already do. Just make sure that the buyer understands that you are going to be doing them. Consumer obligations, again, we're asking the consumer to agree to do all of these things. Most importantly, I think for me is A, right? Conducting all the negotiations to locate the property through you as the buyer's broker. And then also, if they're contacted or if they contact a for sale by owner or whomever, consumer will the first opportunity advise the owner or the real estate licensee that you're working with that particular broker. Again, making sure that people in the outside world understand that you're working with that particular buyer. And read through these, again, read through them with your consumer. This is what you're expecting the consumer to do. Paragraph 6, this is a retainer provision. So some folks would like to include a retainer. This is a non-refundable retainer fee of blank for the broker services. Note that all compensation needs to go through the brokerage. So this is not an opportunity for a licensee to ask for a personal check from the buyer for their services. All compensation needs, including retainers, need to go through the brokerage. So discuss with your broker whether they would like for you to request retainers from consumers, and then ask your broker or review your independent contractor agreement to see how they will address the split of those retainers. All right, most importantly, paragraph 7 regarding compensation, we're saying broker's compensation is earned when, during the term of this agreement or any renewal, the consumer or anybody acting on behalf of the consumer, meaning our buyer, contracts to acquire real property as specified in this agreement or defaults on any contract to acquire property. Quick note here, default does not mean terminate under the normal course of an as-is transaction or under any contingency. A default is a buyer gets cold feet and they have no other out under their contract and they just decide not to close. Compensation would still be due to the buyer's broker. So we want to make sure our buyers understand that as well. So paragraph 7A, again, you get to negotiate your compensation with your consumer. If your model is to charge just a fee, you put the dollar amount of the fee, or if your model is to just charge a percentage, insert the percentage, or if your compensation model is a flat fee plus transaction broker fee, then you check the next set of boxes. So flat fee plus transaction broker fee, or percentage of the purchase price plus transaction fee here. So again, if you are in the adding the transaction fee type of compensation, make sure you're selecting that second set of boxes. So
there is not a new tenant broker agreement. So you can use this document. Buyer has been swapped out with consumer, and there's a lease provision. Because lease commission is also leasing rentals were not addressed in the settlement. but because leasing is coming off of the, because commission is coming off, you might need to enter into a agreement with a tenant as well as to the commission. You would do that through this document as subpart B. I've gotten some questions as to how to maneuver this as to month's rent and stuff like that. You've got month's rent, you've got gross lease value to accomplish for seasonal leases. If you've got something beyond that, you can put it in additional fees. We just recommend that you always work with your broker and their counsel to make sure it's worded properly.
Thank you. Paragraph 8, we're dealing with the protection period. This is a similar concept to what we have in our listing agreement. So again, if after the termination date, the buyer contracts to acquire anything that was brought to their attention during the term of the agreement, buyer broker would be due compensation. And paragraph 9 is revised. The previous version from 2016 of that exclusive buyer broker agreement had a unilateral termination by either party. This is a conditional termination. Again, similar to what we have in our listing agreement, that at the consumer's request, the broker can agree to conditionally terminate the agreement. But if they agree, then the consumer and the broker will enter into a written agreement and pay a cancellation fee of X. So again, you can negotiate that cancellation fee in paragraph 9 up front with your buyer and say, listen, you are, if this relationship isn't working out, if this marriage isn't working out, we can, my broker will grant a conditional termination. Here will be the cancellation fee for terminating. And again, that's always negotiable. Note, though, that the broker can void that conditional termination if after that termination agreement is signed or the cancellation agreement is signed, the buyer goes back and purchases a property that was brought to their attention during the term of that agreement. So, one more thing regarding the protection period, similar to our listing agreement. So we have that protection period, but note that that protection period is cut off once the buyer enters into a good faith exclusive buyer broker agreement with another broker after that termination date. So again, that would be cut off if that buyer enters into another buyer brokerage agreement. We want to make sure our consumers don't enter into too many buyer brokerage agreements at the same time, which could potentially result in them owing multiple brokers compensation at closing on one property. So, okay, dispute resolution, discuss with your broker whether they would like you to authorize arbitration. Other terms, paragraph 13, this makes me nervous. I know it makes Kristen nervous as well. Anytime you see a blank line, pause before you start writing things in there. Make sure if you're going to add language at your consumer's request, or you think that there's some additional language that needs to be added, make sure you're discussing it with your broker, preferably have it reviewed by counsel, just to make sure that the language says what you think it says, there might not be any unintended consequences. One quick note in paragraph 12, the brokerage relationship. This is the difference between all of those 4 EBBA forms. So EBBA TB has the transaction brokerage language in paragraph 12. The other forms will have those different types of brokerage relationship, the single agent relationship that's described in paragraph 12. This is binding on the consumer and the broker. Quick note, make sure if you as a licensee are going to be signing these agreements on behalf of your brokerage that you have the authority to do so. So you're going to want to discuss with your broker whether they would like for you to enter into these agreements, whether they'll allow you as a licensee to enter into a listing agreement or a compensation agreement on behalf of the brokerage. Have that discussion now before you go signing a bunch of documents that maybe you don't have the authority to bind your brokerage. And of course, the big bold language, brokerage commissions are not set by law and are fully negotiable. And we know a broker cannot receive compensation from any source that exceeds the amount or rate agreed to with the consumer. Okay, I know that was very quick. We covered it. So we talked about the other brokerage agreements. Again, the EBBAs, look at the footer, bottom left corner of the exclusive buyer broker agreement, TB, transaction brokers. The different brokerage relationships, again, only appear as a footer, and then look at paragraph 12 for the description of those relationships. We also have a showing agreement. Yes, Kristen, I do call this the dating agreement. So it is specific to particular properties. So let's say you're not ready to get into a long-term relationship, the buyer's not ready to get into a long-term relationship, but they want you to show you these 5 particular properties over the course of a weekend. You need an agreement with the buyer. And so perhaps the showing agreement is a good way to get the buyer comfortable with the concept of working with you and also compensating you upon closing. So that showing agreement, you can list all 5 properties that you intend to show that buyer. And or if the buyer enters into a contract to purchase those properties, you'll be compensated for this. The property pre-touring agreement, it is a form that exists And that's really all I'm going to say about that. My preference would be that we use a showing agreement or exclusive buyer broker agreement. And then of course, there's a modification to the EBBA and the showing agreement. That is a new form that allows you to modify some of those terms of those buyer brokerage agreements. Yeah, I'm gonna keep going. Okay.
Yeah, so I just want to make one quick note before we dive into the next set of forms. Who has the authority to bind the brokerage? So we just spoke about when you're entering into a buyer broker agreement, who can sign. When you're entering into the other agreements between broker to broker, it's important that you check where the agent works and make sure you actually write their brokerage name in the contract. All of that information is available through the license search function on DBPR's website, and I can drop a link to that in the chat once we enable the chat. But look up the agent. Number one, make sure they're licensed, because sometimes they're not. That happens. But make sure they're licensed, make sure you know who their broker is, and then make sure who the qualifying broker is. I would always default when you're having these commission agreements signed by another brokerage that the qualifying broker is who is the signatory. And if they're not going to sign, then they need to tell you why they're not signing. And perhaps that is because they've delegated authority, but at least you have a paper trail as to who was proper to sign. I see a lot of contracts where you take a copy paste of someone's signature line. Sometimes that's not the legal entity. Sometimes that's just a pretty signature line with a, a logo or something. So you've got to make sure you have the full legal name. Okay.
Awesome. Thank you.
Contracts.
So we talked, and when we were talking about the chart, we talked about the compensation agreement, seller to buyer's broker, that's the CASB1, the seller broker to buyer's broker, that's the CABB1, and then there are modifications to each of those. I'm not comfortable saying modification, I say amendments, but they say modifications. So just know the modifications are a change to an existing executed agreement. Again, we've got the link here for Florida Realtors. I feel like every time I say, I mention a reference to their site, they update the website with some new form or new class or something. So please check that regularly for information. There are also multiple classes by Florida Realtors, by multiple instructors, both from an attorney perspective or from a broker perspective. So attend those classes, they are fantastic. I don't think it's important to go through very detailed of these. So you can look at these agreements on your own. Again, we talked about how we're going to use them, but it makes sense that this particular one is signed by the brokers, referencing a particular property. If you know the buyer's name, have it executed. It has a term of agreement and the obligation for the seller broker to compensate the buyer's broker. And in the middle here is the compensation that's being agreed upon to pay that buyer's broker.
Can you go up one? Are we in the broker one, right? Okay, yeah. So just want to make a quick note. Anyone who maybe has not printed their MLS sheet reflecting their commission before it went offline, you may want to go have one of these signed. So just want to make that note real quick. If you have not already, you should have, if you have a pending deal right now under contract that's going to close after the MLS takes the comp field off, you need to have a copy of what that offer was. And if you want to take it a step further to really be protected, you can use this contract. You can even just reference the MLS sheet and attach it and have everybody initial. But this is the form that you would want to use to solidify what those pending offers of compensation were. Okay.
Thank you. All right. Just one quick note, these forms, though they allow, you may have a broker who wants to go ahead and sort of pre-fill this at the time of listing. Just know that this form cannot be uploaded to MLS. Don't reference it on MLS. Don't put it on MLS. Don't put it on MLS. Don't reference it on MLS. I feel like I've said enough, but do not use this as a form. Don't slip it into your seller's disclosure. Don't put it anywhere on MLS. You will be fined accordingly. Okay. Between the brokers that can initial to authorize arbitration, and we know that the compensation is negotiable. This is the form between seller directly with the buyer's broker, again, between seller and the buyer's broker. As a buyer's agent, you are not going to circumvent the listing agent and try to start negotiating directly with the seller. You're still going to work directly through the listing agent to request that offer of compensation from the seller in the event the listing broker is not offering compensation. I want to pause real quick and rewind back to that seller's broker to buyer's broker. I keep talking about this time as a messy middle or a weird period of transition or whatever it is, wherever we are, we're in a strange time. Just think right now, all the listings that currently exist on MLS, chances are they did have an offer of compensation from listing broker to buyer broker, right? The odds are pretty good that before today, if you're in Southeast Florida, before today, there was some sort of offer of compensation. So my guess is, unless that listing agreement has been modified very recently, in the past few days, chances are that listing agreement does include an offer of compensation. So your best bet, again, right now, is to make sure that that offer of compensation is documented in that between that seller's broker to buyer's broker in the coming months. Now, new listings, we may see more changes to those offers of compensation. Sellers may decide that they're not going to offer any compensation to a buyer's broker. That's fine. But I think in this messy middle, weird gray area where you've got all these existing listings, that as of a week ago, you could see those offers of compensation. Those listing agreements had offers of compensation in them from listing broker to buyer's broker. So I would rely on that. Good news. Okay. Again, this is seller to buyer's broker.
Can we go back to dispute resolution real quick?
Yes.
So I just want to make a quick note on the seller to buyer's broker. If on the buyer broker to, or listing broker to seller broker, so broker to broker, the checkbox arbitration is going to put you in the world of mediation arbitration, potentially under the code of ethics, which makes sense. If both members are brokers, you have that kind of service through your MLS membership. You wouldn't have that type of service between a seller and a buyer broker because the seller is not going to be an MLS member. So your dispute resolution clause in the seller to buyer's broker gives you two options: mediate then litigate, or arbitration if you agree to it. The prevailing party fees change in each of those. You want to have a conversation with counsel as to which one you want to go with. There's pros and cons of both, and that's kind of a conversation you have to have. Just know that if you enter into a contract for your commission to be paid directly from the seller, then your cause of action, if it's not paid, is through the seller. So you're going to be out of the world of Board of Realtors. The other thing I wanted to know is that having your compensation forms should be executed before you present the offer. We know that that's not going to be practical in all situations. There's already been a lot of scuttle that sellers, listing agents are not going to tell you what the compensation is until you present the offer. I call this, they're making the buyers make the first move, because all of our references seem to go back to dating, but the buyers are going to have to make the first move. If that's the case, we're going to get into what the ethics rules say on that. But I would still, and that gets a little hairy when you're presenting offers, because purchase contracts could be signed and not the comp agreements, which means your buyer's going to be on the hook to pay your commission based on the buyer broker agreement. So you don't want to do that. So to the extent you can, you're going to try to get these compensation agreements signed before you present purchase contracts. Okay. That's the timing of it. I know that might not work, but for now, try to do it that way and then see how the listing agents you're working with respond to that. Okay.
Thank you. Yes, so we've got some modification forms. Again, when you hear modification, think amendment to a currently existing agreement. If you have a current listing, or let's say a buyer broker agreement on an old form, we've got a couple of scenarios. One is the modification to the listing agreement. That is a new form that was just released on August 6th. So take a look at that form. Again, MLA-6. And then there's the compensation disclosure statement. So we're going to go through those quickly, so we have plenty of time for questions. All right, so here's our modification to a listing agreement. I've got excerpts in two parts. Again, this is for a current listing agreement that, let's say, doesn't have that big, bold language regarding brokerage commission being not set by law and not being fully negotiable, that kind of thing. So this is, again, between the owner or seller and the broker to modify a current listing agreement. You can modify any of these terms regarding the termination date, the price and terms, compensation to the listing broker if that needs to be modified, seller authorizing compensation to a buyer's broker. Let's say they weren't offering compensation to a buyer's broker, or they are, but maybe they want to modify that offer. Again, you've got the opportunity to make these changes here. We've got the big bold language: brokerage commissions are not set by law and are fully negotiable. Also, the second half of that modification to the listing agreement is with respect to lease compensation. Compensation is owed to broker properties transferred within blank days after the termination date, same as that sort of protection period. They check the box to add this if the listing agreement was dated prior to March 31st, 2024. This language, again, other big bold language, the NAR settlement prohibits any requirements conditioning participation in an MLS offering or accepting offers of compensation to a buyer consumer brokers or other buyer consumer representatives. Accordingly, any reference to a requirement that compensation be offered in order to list the property in an MLS is hereby deleted. So again, your listing agreement required a listing in MLS. You're going to check this box to make sure you're compliant. The other terms again in that listing agreement. Yes.
It's if you're the way this is kind of structured, if your listing agreement stated specifically that you were going to offer compensation, so listing agreements entered into before today, if your listing agreement says that you were going to offer compensation specifically on the MLS, then technically you would be in breach of contract because you can no longer do that. That's the case, you're going to have to go back and amend and dictate how that compensation is offered. If it was not directly tied to the MLS, then you may not need an amendment. However, if you had any customers or consumers that you were working with that specifically stated that they did not want to offer compensation and therefore not go on the MLS, all of those folks should be given the opportunity to now go on the MLS with it because compensation is no longer offered. So if they check the box, I don't want to go on the MLS because I'm not going to offer compensation, all of those should be given the option now to go on the MLS now that compensation is not out there. There is a requirement, we're going to get to it in a minute, that you notice pending if you have an active listing, an active buyer broker agreement entered into before the disclosure language came out. Oh, okay, it's next. Then you have to provide this disclosure. The disclosure is notice to buyer, buyer seller, broker compensation, it's not set by law, and it's fully negotiable. That is actually it should say broker commission, but that's what the settlement says. But it says this is the disclosure that's supposed to go out. It doesn't have to be signed, it just has to go out. So if you've got any of those active listings, active buyer broker agreements that are not yet under contract, they should receive a copy of this. Okay, so how you want to handle that is up to you, but technically you're supposed to notice everyone that this commission is negotiable.
And Kristen, it isn't the case that some brokers have decided to include this type of language in their own type of communication with their customers. But as long as it has this information, they would be compliant. Okay, let's talk generally about credits, and then we have we'll have plenty of time for questions. We've got a couple scenarios that I think we'll try and send out for questions. All right, talk about credits in our sales contract. You already said who it's between, right? Between the seller and the buyer, not involving brokers because they're not signing those sales contracts. So for what purpose?
So we all know what credits are. Credits can be for a variety of things, and they can flow between a buyer and the seller. They can also flow between a broker and a consumer in the transaction. We're going to get into the statute or the rule that allows that. But you know what credits are. Credits, concessions, all those things are things that you've already kind of worked into your transaction in the math problems that have always presented themselves in real estate transactions. So you get to the end of an inspection period, buyer threatens to cancel because of a leaky roof situation. You got to negotiate money from one side of the closing statement to the other side of the closing statement. And that is particularly done either in a change of the purchase price or some sort of concession. Or credit. So that's what we're talking about when we're talking about concessions and credits. If money is flowing from a broker down to a consumer in the transaction, either the seller or the buyer, that is subject to this rule that's on the screen. This is a rule that falls under Chapter 475 and is related to the sharing of commissions with non-licensees. That is considered a kickback and is illegal in the state of Florida, unless subsection 2, the sharing of brokerage compensation from a licensee to a party to the real estate transaction with full disclosure to all interested parties, which I interpret to mean the closing agent, the lender, the buyer, and the seller, is not considered a violation of Chapter 475. The practical way of how you document that would be a letter. This is what a good, in my opinion, closing agent would require, is a letter on company letterhead signed by the broker, qualifying broker of the company, saying that the credit can be authorized and how much that is. So that's how you would do a credit or rebate from a broker down to a consumer. And that can flow both ways. That can flow from one agent to two consumers. It can go a variety of ways as long as there's transparency. Now Next page.
And authorized by the broker.
And authorized by the
because
broker.
what sometimes those, and the reason she's saying this broker authorization letter, a broker letter, letterhead authorized by the broker is because we sometimes see addenda to contracts, which are amendments, addenda to contract saying listing broker shall provide a credit to buyer in the amount of X dollars. Listing broker is not signing that addendum to sales contract, right? Seller and buyer are the only ones who are signing that addendum to sales contract. So you really need that broker authorization, broker letter confirming that they're authorizing that credit. Okay. Financing issues. So we know that there are sometimes caps on interested party contributions that a buyer can receive. So a credit from seller to buyer, or credit from an agent to a buyer. There may be some caps on those types of contributions or credits that a buyer can receive in a loan closing. So we've got some updated Fannie Freddie guidance. This is something you should be following. This is, again, all of this is in flux, but current Fannie Freddie guidance is that the seller is providing a credit for an item that is customarily paid for by the seller, then it is excluded from those IPC limits. So you could have a credit towards buyer's closing costs and prepaids in the amount of X that needs to be below that interested party contribution level. Perhaps, though, if there's a credit from the seller to the buyer for something customarily paid for by the seller, let's say like buyer broker compensation, that potentially could exceed that IPC limit. You just need to be specific with the language that you're using to describe that type of credit. Again, we've got a link to the Fannie Freddie memo on that. And also, we know that traditionally under a VA loan, buyers are prohibited from paying real estate agents compensation. There has been a temporary suspension of this rule as the VA kind of goes through to help figure out how they cannot disproportionately impact VA buyers. So stay tuned on that. There also, the FAQ from NAR was recently updated to talk a little bit about that. So I encourage you to take a look at that. There won't be any issues, Kristen. I know we have an issues slide here, but there really won't be any. Everyone's going to document everything perfectly. It's going to be wonderful. Folks are going to negotiate up front, have their buyer broker agreement up front, and perhaps all or some of that compensation will be properly documented from the listing broker or from the seller direct to the buyer broker. But
there could be issues. Okay, so let's just talk about
yeah.
practice. I like to focus on what we can do because control the controllables.
Yes.
The controllables are you get your listing agreements and you get your buyer broker agreement signed with clear compensation of what you're going to be agreed to. You negotiate the commission up front before you present the purchase contract. And as soon as the purchase contract is signed and all your commission agreements are executed, dictating how the listing agent and the buyer broker are going to be paid, that you give that right away to the closing agent so that everyone, and make sure everyone knows what the compensation is, and do this before closing, way before closing, right after the execution of the purchase contract. Make sure everybody's. The reason for that is when that preliminary closing statement comes out and the commission is on them, there are no surprises. There still could be disputes, but there's going to be less likely chance of a dispute if everybody is on the same page. And the only way we're all going to get on the same page is if everybody has a contract that says what the page is and everybody gives that to the closing agent and the closing agent knows as well.
Yes.
So Erin, closing agent, what are you gonna do?
I want give me all the documents. Show me how the compensation is going to be allocated so that we can properly put it in the correct column on the settlement statement. But I will tell you, so Kristen and I have taught a similar version of this class for the Florida bar, and there are a lot of attorneys and title agents who do not yet know they need to ask better questions. So I'm trusting all of you who are here listening to this presentation to make sure that you are informing your closing agents how they need to address compensation in the settlement statement. So they may be surprised to receive a copy of a buyer broker agreement and say, well, why are you giving this to me? This is just between you and your buyer. So, well, here's why this matters, right? Here's our purchase price plus the buyer broker agreement amount. And then let's say a portion of that is offset by the listing broker. Your closing agents, title agents, law firms are going to need to start asking better questions, but they don't yet know to do that, and they don't yet know how to do that. So perhaps there was a world where they were previously relying on offers of compensation on MLS that no longer exists. Now they're going to say, well, shoot, I need to find out the information. My hope is that closing agents start asking better questions, not just how much money are you anticipating buyer's agents, but how much money and from whom? How is this particularly allocated? So if you have a commission verification form, if you use one in-house that you provide to your closing agents, or if the closing agent sends you a form for you to complete a jot form, for example, make sure it is comprehensive and it accurately reflects how compensation should be reflected on the settlement statement. Kristen and I are going to do another presentation for the Florida Bar, hopefully very, very soon, because there's more forms that are released and we have better guidance now. But this is my plea to you, everyone who closes a transaction, inform your closing agents that they need to ask good questions to be able to get all of the information to be able to add and appropriately allocate to the settlement statement. Okay, that is my little soapbox. What do we do in the event of commission dispute? Let's say a buyer can't pay, doesn't want to pay, seller doesn't agree to pay, broker threatens to sue, brokers have dispute with each other. Make sure you have a good line of communication with counsel who can represent your brokerage. Let your broker know as soon as a potential dispute arises, make sure you're having that conversation with your broker and they can determine how they'd like to pursue or not pursue enforcement. Kristen, is your hope that enforcement of these agreements will become easier as time goes on?
Yes, and I will say, I think they already are. I think people are starting to recognize them more than they did years ago when these were really only seen in commercial context. So yeah, I think it's going to become easier to hopefully, or not, I shouldn't say easier, but more recognizable, these form contracts. But hopefully that means there might be an uptick in litigation, just suspecting, but hopefully once everybody gets a handle on this, hopefully that goes away. I do want to tell everyone just a couple of things related to the code of ethics. So code of ethics is what you agree to as a realtor. In my opinion, that really needs to be revamped, but I don't work for NAR, so I'm at their grace for when they revamp those code of ethics. But there's just some certain things that you have to follow. There's also just certain elements of being a licensee in the state of Florida that you need to think about when you're pursuing your commission. So you can pursue your commission and you have a right to be paid, but you also have an obligation not put your consumer potentially in an issue where they're going to be hurt. Remember, FREC is concerned with consumer type issues. Is the consumer being harmed? If you prevent a closing and cause a consumer to default on a purchase contract because you've prevented the closing from happening because of a commission dispute, you could potentially be putting yourself in some hot water from a licensing standpoint. That doesn't mean you don't have a right to get paid. I just tell you to work with all those types of situations very cautiously with counsel, with your broker, to make sure you're doing things in a way that's not going to hurt your consumers. Okay. That's number one. Number two, there's a code of ethics that talks about 3.1 that talks about how commission really needs to be worked out before purchase contracts are entered into. That now seems like kind of obsolete, but it's still on the books. So I just mentioned that because there is a lot of listing agents that are going to say, I'm not going to talk about compensation until we see the offer. And I think that makes sense. Like, I want to see the total picture. My seller wants to see the total picture before we figure out how the compensation is offered. Technically, that doesn't work under paragraph 3, practice 3-1. I kind of highlighted language here. If any terms of compensation, if any, shall be ascertained by the cooperating before beginning efforts to accept the offer. I don't know how that's all going to change. So we're in a state of flux. Yeah. I just want you to be cautious on how you negotiate this to the best of your ability. If you think about transparency to the consumer and try to play nice in the sandbox to the extent you can with your other brokers, that's going to go a long way. Lien rights, there's commercial lien rights acts, or there's lien rights set out in Chapter 475 related to commercial transactions. There are not the same lien language is not in the residential version of Chapter 475. There is language that says if you separately agree with your client to lien rights, that can be enforceable. But in the context of buyer broker, you wouldn't be able to confer lien rights because you don't know the property when you enter into the buyer broker agreement. And the buyer doesn't have compensation. But there could be rights to pursue lien rights. In which case, if there's a lawsuit, a judgment after closing, it could impact the property, which impacts the buyer's ability to sign the borrow affidavit and all sorts of issues. So these commission disputes can have impacts on both brokers who are expecting to get paid, maybe, and don't get paid, but also on consumers who maybe don't have a good understanding of what their obligations are under the contracts they've signed. So your best bet is to make sure everybody's on the same page and know those numbers.
Awesome. So we will send out the slides as resources. These links are all clickable links. So we just have a few references. Again, if you're not familiar with the NAR FAQ, become familiar with it. If you are not refreshing your browser every couple of minutes on the Florida Realtors website to see what updates they have, start doing that. Also pay attention to the local boards. I didn't add the Naples Area Board of Realtors link here, but if you practice in Southwest Florida, know that you've got your other set of forms. Those are constantly being updated, and by constantly, trust me, they are being updated constantly. So if you need the most up-to-date forms for the Naples Area Board of Realtors, they may not appear in your vendor packet yet. So make sure you stop by the website in the top left corner under the vendor NABOR contract section. You'll find the most up-to-date versions of the contract, and of course attend any of the classes by any of the great instructors by the Naples Area Board of Realtors. Now, we are trying something new soon. If you are a broker or a team lead, if you're a broker or a team lead, we're going to have an Ask the Attorney Zoom. If you are interested in participating on Friday from 10 a.m. to 11 a.m. an Ask the Attorney Zoom, broker Q&A, compliance is greater than complaints. Send us an email, info@getclosedgetpaid.com, and we'll send you the link to register for that Zoom. Again, that will be sort of a free-flowing conversation between brokers and team leads.
Terrible
talk about
person.
sort of, Kimberly, can you please mute yourself? So make sure that we're going ahead and if you would like to participate, again, info@getclosedgetpaid.com. You can participate if you are a broker or a team lead in our inaugural Ask the Attorneys Zoom. Okay, if you have any questions, you're welcome to send us an email if you don't want to ask the question live on the Zoom. Again, all of our classes are recorded. They will be posted on our YouTube page and also on our individual firm websites. Please follow us on Instagram. Follow Get Closed Get Paid at getclosed.getpaid for upcoming classes. We do have a new class every Tuesday, second Tuesday of the month from 10 a.m. to 11 or 11:30 a.m. So please feel free to join us. And again, our classes are recorded and uploaded. Did I miss anything, Kristen?
No,
You think
thank
we're
you
good?
guys. Yeah, thank you for joining us. I'm going to go ahead and stop the recording and enable the chat.
Sounds
So
good.
stand by.
Awesome. Yep. Thank you. And if you do have